a lot of people have been sending requests to me to clarify the distinction between Bharti Airtel case of Delhi High Court, revenue appeal dismissed by Supreme Court in August 25, and the Safari Retreat. Now friends, both are dealing with restrictive clauses under section 75 C and D, but both are on very, very different footing. In Safari Retreat, the issue was of constitutional validity of section 17.5 C and D, whether ITC can be blocked, and they were dealing with properties which are immovable. Whereas in Bharti Airtel, the case was of whether the telecom towers can be deemed to be movable properties and therefore ITC allowed. Both were dealing in 17.5. Bharti Airtel were dealing with an exception of 75, whereas in Safari Retreat, Supreme Court was considering the constitutional validity of the 17.5 C and D, the provisions where the ITC is blocked. Now, Supreme Court did not decide the issue, but gave a little bit hints that if a commercial mall can be held to be a plant from which the assessee earns income and pays tax, then input tax credit can be had. To effectuate this proposition, they laid down a functionality test that the courts will have to consider what is the function of a particular immovable property, and if this can be held to be a plant, then ITC can be given, and therefore Supreme Court remanded the matter to High Court to consider whether the shopping mall which were being built by the petitioner could be held to be a plant. Whereas in Bharti Airtel, contrary to what people talk about, Bharti Airtel did not discuss Safari Retreat at all. So we have to remove this doubt. I see a lot of people, Bharti Airtel considered Safari. No, Bharti Airtel's Safari Retreat was not discussed at all. Bharti Airtel, the question was whether the towers being put on the cement and sand stands with screws and nut bolts, could they be held to be movable property? After the evidence was given by the company that these towers can be taken anywhere whenever they want, barring the cement concrete stands or the platforms or whatever you call them, then the High Court decided that these towers for telecom transformers, telecom towers cannot be held to be immovable. They are movable, therefore input tax credit is available. So the difference was not only of the classification dispute, not only of the constitutional validity and its challenge, but also the basic premise of movability and immovability. Therefore, Supreme Court, Safari Retreat, the issue was different. Bharti Airtel, the issue was different. Now the issue comes that Bharti Airtel judgment was taken in SLP by revenue before Supreme Court. Supreme Court dismissed the revenue SLP in August 25 at the threshold. There was no detailed judgment by Supreme Court except they confirmed the Delhi High Court judgment, which is the law of today. So therefore, if we have to apply Article 141 to Bharti Airtel, in my opinion, this can be applied safely. But the government took a stand that the Safari judgment is contrary to the legislative intent, where input tax credit was to be denied for creation of any immovable property, even if it is held out to be constructed for the business purposes. Therefore, government retrospectively amended the definition and fulfilled the deficiencies which were pointed by Supreme Court, plant and machinery or plant or machinery, and they nullified the judgment of Supreme Court. With the retrospective cancellation of Supreme Court judgment, I think the benefits that were given by Safari Retreat are over. Now those benefits cannot be had, the input tax credit cannot be had unless the challenge which has been made to retrospective amendment by Parliament is upheld, and they say that this retrospective amendment cannot be made. So we'll have to wait and see. However, in case of Bharti Airtel, there was no such amendment, and the amendment made post Safari is not broad enough, in my view, to nullify the judgment of Bharti Airtel. Therefore, friends, this is the fine distinction between Safari Retreat dealing with immovable property, who laid down a functionality test, who remanded the case to High Court whether the shopping mall can be held to be a plant for the purpose of GST, was different footing. This judgment has been nullified, whereas Bharti Airtel, the Commissioner GST versus Bharti Airtel, stands today as SLP of the revenue, has been dismissed by Supreme Court in August 25. Should you have any more query, write on my Facebook. I will try to clarify further. Thank you.